7 candidates have been whittled down to 2 in the race for Honolulu Prosecutor. The winner will only be the 4th person ever elected to hold the seat, and neither candidate has held an elected office before. The race pits former Circuit Court Judge Steve Alm against criminal defense attorney Megan Cow. Each have a different vision on how they would run the prosecutor's office. Tonight's live broadcast and live stream of Election 2020 on Insights on PBS Hawaii start now.
Aloha and welcome to Insights on PBS Hawaii. I'm Lara Yamada. A year and a half after receiving a target letter amid a federal corruption investigation, Honolulu's prosecuting attorney Keith Kaneshiro remains on paid leave. After deciding not to run for re-election, a crowded field of candidates jumped into the race, but only the 2 top vote-getters will be on the November ballot. We look forward to your participation in tonight's show. You can email, call, or tweet your questions, and you'll find a live stream of this program at pbshawaii.org and the PBS Hawaii Facebook page. All right, now to the candidates. Megan Cow is a trial attorney specializing in civil, personal injury, and criminal litigation. She is a graduate of UH Manoa and the Santa Clara University School of Law. Cow worked as a deputy prosecutor at the Honolulu Prosecutor's Office for 4 years before moving on to work for 2 civil litigation firms, and she now has her own private practice. And Steve Alm was a circuit court judge in Honolulu for 15 years, leaving the bench in 2016. Before that, he served as the United States Attorney for the District of Hawaiʻi and was also a deputy prosecutor. In 2004, he launched Hawaii's Opportunity Probation with Enforcement, or HOPE. The highly supervised program gives felony offenders rules to follow in hopes of reducing probation violations. All right, thanks to both of you for being here tonight, and we'll go ahead and jump right into the questions. And we're going to start with something very current related to COVID-19. And Mr. Alm, we'll start with you. This question to you first. Do you agree with the Hawaii Supreme Court ruling to temporarily release certain pretrial detainees to alleviate that overflow in Hawaii prisons due to the COVID-19 outbreak?
Well, I think something could have been done before that, and that is looking to the Department of Public Safety to adequately supervise the people in their custody. So that means we should have looked to them to be doing physical distancing, testing of everybody. I've been saying this for months. Have the ACOs, they should be living at a hotel like other first responders. And they could have used gyms, they could have used courtyards, they could have used temporary structures so the inmates could practice physical distancing for a 2-week quarantine and then put them back into a cleaned out cell in a module. And it was a false choice, I think. Either keep them as they are, which is too crowded, 2 or 3 to a cell, and not test them, or to release a whole bunch. So my preference would have been to have the Department of Public Safety step up months ago and do the testing of every single person, of all the civilian employees, of any new admissions to jail. And then you wouldn't be faced with that kind of a challenge. And
Ms. Cow, to you.
I actually objected to releasing any of the inmates early just because of COVID. And the reason is because these inmates have already gone through a hearing where a judge has determined that they are not safe to be in our community. A judge has objectively looked at their file and decided either, number 1, they're not going to come back to court when they're required to, or number 2, they're going to reoffend while in our community. And so to release them without supervision was completely objectionable. I agree the Department of Public Safety should have been taking other measures prior to just releasing these inmates without supervision. For example, the Department of Public Safety could have looked at churches and assigned 1 Oʻahu Intake Service Center officer to each church with 15 to 20 people and supervise them and make them check in at certain times. Or look to the stadium, or look to Waiava, which is the other facility that they run. But I was not at the table. I didn't have a seat at the table. I wasn't involved with the Department of Public Safety, the prosecutors' discussions, and the public defender's discussions. And I never want to backseat drive things that people have already decided. They have to make decisions right away. However, I did object to releasing the inmates early without supervision, without programs, and without any type of services.
And Steve, actually, I wanted to follow up with you. Actually, go ahead. I was going to ask about some of the alternatives that Ms. Cow brought up.
Well, this is something that we're going to be dealing with in the future. I think HPD has done their part over the months where, when appropriate, they'll defer an arrest if it's not a danger to public safety, or in other cases, they're citing people, because that's where the inflow into the jail comes in. And at the same time, because of physical distancing requirements, there has not been real supervision going on. And there's no drug testing, because you've got to be up close and personal for observed urine tests in order for that to happen. And this is going to continue. So I think the Supreme Court looks at it. As a judge, I always think there should be a case-by-case review so the prosecutors can make their objections to any proposed release. And I think one of the challenges of just looking at the instant case, the case they're in jail for, say they got probation, 4 years of probation and 18 months in jail. The problem with just looking at the current offenses, it doesn't look at the priors. And so somebody could have a nonviolent theft right now, but maybe they have 4 convictions for abuse of household member. That's a dangerous person, particularly they get out, they're going to go back to that location. And so I think it's the kind of thing that I can see the Supreme Court's position. This is a really crowded place. Public safety hasn't figured out a way to physical distance. So I was always in favor of having case-by-case review, because then the prosecutors can lodge their objections. But releasing people is not a new thing. I mean, when people can't make bail and they're sitting in jail, defense attorneys, public defenders, private counsel like Ms. Cowell will be filing motions for supervised release. But at least it comes in front of a judge. Prosecutors can lodge objections.
Any other thoughts to that?
Yeah, here's the problem with releasing the inmates just by category itself. The Hawaii Supreme Court decided that all misdemeanants and petty misdemeanants could be released no matter what the charge was. We have a man named Rocky Ben. On August 21st, 2019, he committed a CPD for criminal property damage in the 4th degree, and he was released because of COVID. On December 14th, on February 7th, he was released. On December 4th, 2019, he committed a theft in the 4th degree, and on February 7th was released. Not even a month later, March 9th, he commits criminal trespass in the 2nd degree, is released right away on March 10th, and on March 16th, just 6 days later, he assaults a 74-year-old man who owns a CPA firm where Rocky Ben was staying because he was homeless and didn't have anywhere to go. And so that's what we're looking at, people re-offending in our community just because they're released purely because of COVID.
Now, I do need to move on, but a short response.
Finally, as part of the example of why this is going to continue, just this afternoon, an attorney filed a motion because his client didn't fit into one of the categories that were subject to release, because the Supreme Court kept out certain categories like burglary in the 1st and 2nd degree. So this person, his client, was in there on a Berg 1 serving 18 months. So he's trying to get them released as well with a writ to the Supreme Court. So this is going to be an ongoing basis. No matter who wins this election, they'll be dealing with it in January, just like they're dealing with it now.
So I think this is a related question that was most certainly getting a lot of press pre-COVID, and that is the population situation in the prisons, which may have been, in some perspectives, adding to the situation that we're dealing with now. So getting back to that, because that obviously is going to be back on the table sometime again soon. So talks to build a new prison facility on Oʻahu, overshadowed maybe in many ways by this pandemic. Do you feel that a larger facility is needed to help address the overcrowding? I'm going to start with you, Ms. Cow.
So overcrowding is not a new concept. This is not something that just happened within the past couple of years. OCCC, which is our jail, has been overcrowded for over 20 years now. And so a new jail is needed not to imprison more people, but to take care of the people that we already have in our jail system. Jail is for the people that are facing less than 1 year sentence or that are pre-trial felons that haven't had their trials yet. Prison, which is in Halawa, which is not overcrowded, is for the people that are serving time that is greater than 1 year. And Nolan Espinda went on the record last year to confirm that Halawa is not overcrowded.
Your response?
Well, what we're talking about is a jail, right? Jail is pretrial confinement. Jail is people can't make bail or are sentenced to a certain term of incarceration as a condition of probation. What I would, and there's no question, the rail is going to go down Dillingham, and OCCC has got to go somewhere else. I don't think we should be spending $525 million, which is the current projection, which is no doubt optimistic, to build a new jail. What I think we ought to try first is an all-hands-on-deck effort by the governor, by Senator Schatz, Senator Hirono, and our representatives to buy the federal detention center. It was built 20 years ago for $170 million. We could buy it, hopefully buy it for the same amount we paid for it. And it's in great shape right now. It's out by the airport. You're not going to have a NIMBY, not in my backyard problem. You're just replacing it. Nobody escapes from there. It's close to the airport. It's closer to the courts. And if that's $170 million, you could use another $100 million for treatment programs, for drug and alcohol programs, and it would be less than half of the cost of a new jail. And I think if our whole state, our leadership went all in on this, I think we could convince the federal government, and we'll tell them there are 300 federal prisoners, we'll keep them locked up as well, but there's 600 cells, double cells, 1,200 people. It's almost a turnkey operation to replace OCCC with the federal detention center.
Your thoughts?
That's not a realistic option. We have federal detention center inmates because we have a federal system. The United States Attorney's Office prosecutes federal cases, and they are not going to stop prosecuting their cases. So we need to put them somewhere. In addition, the federal detention center system has been shipping people from the mainland to Honolulu sporadically to use Honolulu as a waiting area for inmates that are not designated in certain places across the nation. And so I'm not sure that that is a realistic option.
I think it's totally realistic. And like I said, they have 300 inmates. We'll tell the feds, we'll keep there. I was the United States Attorney when that site was picked. And the biggest objection always is anybody living near it is afraid of it. The closest people living to it are people that live at Hickam Air Force Base behind a huge wall. They may not even be aware of it. I bet a lot of local people go to the Inter-Island Airport and see what kind of looks like the Ilikai, but with skinnier windows. That's the federal detention center. I think we could save a passel of money. And if there's one thing we all know based on the COVID is money is going to become really hard to come by. The legislature is going to be trying to help people feed their families, get back on their feet, do a job. They're not going to be eager to spend $500, $600, $700 million on a new jail. We should explore the FDC option first.
And speaking of prisoners, Hawaii prisoners, I think this is another issue that has been discussed for years and years and years, are Hawaii prisoners that are in mainland facilities. No doubt going to continue to be on the table as to how we should deal with that population and what we can do. Your thoughts on that, Ms. Cow, as to if you are elected, how you would want to address that long-standing issue?
Yeah, I mean, that's another issue that's not going to just go away automatically and just with the prosecutor's participation. The Department of Public Safety, hopefully will get a director in there that is familiar with new programs and modern programs so that we can start providing the inmates with treatment. Treatment is the most important key factor for any rehabilitation and reintegration into society. And right now, the programs that are offered to inmates are just archaic. And so I'm hoping that the director of the Department of Public Safety chooses a programs director that is up with the times, that is new, and can offer new programming to the inmates so that we are more efficient in reintegrating defendants back into the community.
And your thoughts, I think the initial question being about Hawaii prisoners who are being held on the mainland, sort of how you might, if you get into office, deal with that. I mean, it's been a public issue and a discussed issue for many years.
Well, as the Honolulu prosecutor, you've got a voice. You can talk about things. People want to hear from you. And you're the one who is prosecuting people and helping to fill these facilities up. And I was the toughest sentencer on the court, so no question, a certain number of people have to be sent to prison. That's going to continue. But I think it's our state shame that we send inmates out of state to another state to do their time. We should be taking care of our own people. It cuts them off from their families. At the same time, I've talked to inmates, they'd rather go to Arizona because they can take classes. They can take vocational classes. They can get GEDs. They can, take other things. And so they'd rather go there rather than staying here. Now, there's drug treatment program here at Halawa. There's drug treatment at Waiawa Correctional Facility, Cashbox. But the research is clear. Drug treatment is more effective out in the community than it is behind bars. So they should offer classes and all sorts of things. Maybe there's a role for drug treatment in prison, but most of it should be done out in the community. And if guys do their time, maybe start at a residential inside, then go on the outside to do intensive outpatient and aftercare.
And this is also what you touched on as well, too, as far as just improving the programs within the system.
Yeah, I mean, part of the problem is we have older people running the state that are not up with the times. And, things that worked 20 to 30 years ago, they just don't work anymore. The criminal is new. The law is new. The criminal activity is new. Criminals are smarter. They're more intelligent. They're more conniving. They're more manipulative. And so you've got to be able to keep up with them and treat them at the same time.
So let's talk about yet another. Many of these issues have been talked about for so long. A disproportionate number of Native Hawaiians in the correctional system always comes up during election. Always comes up every year because there's so much research now that really shows some of the issues into why this might be happening to a degree. Your thoughts on now, today, what needs to happen, what can be done to help in this area?
I believe that the prosecutor needs to be a community leader. The prosecutor should inspire people, go out and talk to people and educate people. This is a socioeconomic issue, and Hawaiians have suffered because of crystal methamphetamine, because of the revolving door, because young kids are raising families when they're not equipped to raise children. We need to start educating our Native Hawaiian population and our Pacific Islander population. And I will say the biggest downfall of our community is crystal methamphetamine, and we need to educate people.
Your thoughts, Mr. Alm?
Well, first, at the prosecutor's office, you need to create a culture of high ethical standards, of doing justice, not just winning cases, making sure that all races are treated fairly from the original case charging through plea agreements and trials to appeals. At the same time, I did implicit bias training. We can all learn from that as a judge. That would be something good for the deputies to undergo. But we also have to actually look at court programs that have been proven by research to help different ethnic groups. And a program like Hope Probation, where a rising tide helps all ships, they actually looked at that. And research from Pepperdine and UCLA showed that Native Hawaiians who were in Hope got their probation revoked and were sent to prison 35% less often than if they were in regular probation. And because the Hope judge supervises more than 2,000 people at a time, that means that in the last several years, hundreds of Native Hawaiian men and women have succeeded on probation, are in the community, working, paying taxes, being part of their families, because they were in Hope rather than in probation as usual. And I'm the rare judge and a prosecutor who believes in looking at data and research to drive criminal justice policy. not basing it on gut feelings or anecdote or hearsay, or even more dreaded, we've always done it this way. You've got to be innovative, you've got to be willing to try new things, but you got to look at research and be research-based to make decisions.
Your thoughts?
So Steve Alm has been around for a very long time. He's done many things for our community. Hope Probation, when he started it, was extremely effective and it did help people, but it's not doing what we intended it to do anymore. What's happening now is the defendants are gaming the system. They understand that all they have to do is admit to smoking crystal methamphetamine. They sit in the jail cell for 3 hours, and then it's 3 days, and then it's 5 days, then 7 days, then 11 days, and they are getting 16, 17, 20, 30 chances at Hope Probation. And people are sick and tired of the revolving door. People are sick and tired of watching TV and seeing people with $20,000 cash bail warrants only being arrested only to be released 3 days later. Hope Probation is just not working. And in 2018, the Journal of Contemporary Criminal Justice came to that conclusion. They said, it is the collective responsibility of corrections researchers to warn policymakers that the Hope model is not a proven intervention and may not be effective in many agencies. Also, the National Institute of Justice came to the same conclusion. It simply is not working anymore.
I'm guessing you'll want to respond.
As I said, data and research. So if Ms. Cow has data and research to show what she's saying rather than anecdote, she should by all means bring it forward. But 33 states are doing versions of Hope, and having a program implemented the right way in other places is extremely difficult. And with Hope, you've got caring probation officers. Ours are all social workers from UH. They want them to succeed. It's not a punitive-based approach. You have to have the right judge who's going to be supportive, caring, but strict, like a good parent. And then the sanctions component helps it work. Now, some places have done it well, some places haven't. And the study she pointed out was people in Texas tried it, people in Arkansas tried it. All they did was look at the sanctions. And you can look this up. The people doing it didn't talk to us, they didn't call us. We were not involved in training it. It was a one-legged stool instead of 3. The best example of a large-scale program based on Hope is Washington State. They put all 16,000 people in their parole system into their version of Hope called Swift and Certain. Washington State University did it, and you can look at that research. The people in Washington State's program got arrested for new crimes 20% less often and 30% less likely to be convicted of a violent felony. In the first 3 years, they saved $40 million that they could then use for other programs. So the fact that, a program works in one place or another, you've got to look at what went behind it. The good news is we have the research showing it works well here. If now in the COVID crisis there are problems with any probation program, I don't doubt that. But that is not a fitting indictment of Hope Probation. We have the research here to back it up. And if other places can't do it on the mainland, that's their problem.
Now, I do need to move on, but I know this is a big issue, and he did throw out the question to you, so I want to give you a chance for a short response.
Yeah, so Steve is asking for actual data, right? The National Institute of Justice in November of 2018 came out with this study. It's an actual study, and it concluded that the researchers reported that Hope probationers proportionately committed significantly more violations than members of the control group, and that the actual number of violations was higher for the Hope group as well. And so this is an actual study that has been done to show that Hope Probation is just not working.
Very briefly, we need to move on to some
as
questions.
I said, in Hope, you get sanctions every time you use drugs, you get a sanction. So there are more sanctions. But again, what she's pointing to is the research with places like Texas and Arkansas that tried to do it without learning the right way to do it. So when I said, if she has data and research about Hope in Hawaii not working, I want to hear that, 'cause that would
I
matter.
do need to move on because we have a stack of questions here, and I want to make sure I respect our viewers who are putting in these questions. So we're going to bounce around with some related subjects. This one is from Ellie in Nu'uanu, and wants to know, and we'll start with you, Ms. Cal, your opinions on private prisons.
I don't have a lot of experience with private versus public prisons. I will say I see the way the Department of Public Safety is run. It's very difficult to get ACOs to do things. OCCC is disgusting. I cannot believe that inmates have to live there. It's dilapidated, it's dirty. The food sits out for 4 hours with bugs crawling on it. I mean, inmates should not be subjected to this. It is inhumane. And I will say that is a big reason why we do need to build a new prison, because we need to take care of the inmates that we have now.
Mr.
Okay, 2 things. One, what we're talking about is not building a new prison, it's building a new jail to take the place of OCCC. And second, your question was about private prisons. That is after sentencing by judges. And OCCC
You're right. It's
is
important.
a jail,
It
not
is
a
important
prison.
that you're making this clarification. So thank you.
Yeah.
Both of you.
And so on the mainland, like I said, it's a shame. We shouldn't be sending people to do that. That's a government function. That should be a Hawaii government function. At the same time, as I said, inmates tell me they'd rather go to the private prison on the mainland because they can take classes, they can learn skills that they can't here. So what we need to do is get the Department of Public Safety to offer classes, to offer things so defendants who are sentenced want to stay here to improve themselves. Then they can see their families, because research is clear. If you have a good family connection, you're less likely to recidivate later.
And so another question and this is from Triple HRC on Twitter, and you touched on cash bail at one point, and that's most certainly something that comes up as far as whether or not the system needs to be reformed. Triple HRC asking it this way, saying, what measures would you take to reduce the burden of cash bail on those limited or with no economic means?
Okay, well, there's no question that cash bail helps people that have money and are well off because they can pay the bail and stay out. And people that are poor end up going to a bail bondsman and giving them 10% of if it's a $3,000 bail, they give them $300, never to see it again. So that does discriminate against poor people. But I have just as big an objection that if somebody they can be the biggest ice head on the island. If they can make that $3,000 bail, they're not supervised at all. They're not drug tested, they're not monitored. And so cash bail has been around for a while. I think it should be replaced, but you don't do that until you have another system in place. That means judges on call and available, so if somebody gets arrested, the judge can be involved right away to make a decision on, can they be released on their own recognizance? Can there be a signature bond like in the federal system? Or should they be subject to supervision? And that means bulking up the Oʻahu Intake Service Center at the jail so they can do it. In Washington, D.C., they have a pretrial services agency that does a very good job of this, and I dare say they have more dangerous defendants than we do. They let a lot of them out, they show up for court, and they don't commit new crimes. But that means providing active supervision, and that means providing programs and other things in the pretrial phase. So cash bail can be replaced, but it's a big job, and it needs to be done right.
Your thoughts, your approach.
We are not set up right now to get rid of the cash bail system. Cash bail is an amount of money that a defendant has to pay in order to get out of jail before his or her trial starts. And in order to do that, they can do one of 2 things. Either number 1, pay the cash amount to the court, and at the end of the court hearing, you get all of your money back if you've complied with all the terms and conditions. Or number 2, you pay a fee, typically 10%, to the bond company so that the bond company can post the bond and supervise you pending your trial before your trial starts. But in December of 2018, our judiciary submitted this report to the legislature saying that we are not capable of getting rid of the bail system in Honolulu because the Oʻahu Intake Service Center, which is the division of the Department of Public Safety, is simply not equipped to monitor all of those defendants. And so This report makes it very clear we cannot get rid of the cash bail system in Honolulu.
I do want to move on to some other questions we have here because we have quite a few. This is coming from the Drug Policy Forum of Hawaii, and maybe to you first, Ms. Kao. Will you support prospective legislative efforts to legalize adult use cannabis in Hawaii?
I have taken the position that the prosecutor should never use his or her position to legislate. The prosecutor's duty is to objectively apply the criminal laws to anyone that violates the law, whether rich or poor, local or not local, homeless or not homeless. I cannot go and lobby for certain laws that I believe should be passed or not passed. That's how corruption starts, because the prosecutor's office, although it's an elected position, it is not a political position. And once you start going down that political route, you become corrupt.
Your thoughts?
Well, there are two questions. The first thing is I would object to legalizing marijuana. I think we should decriminalize it so it doesn't have, which is the path we're taking. We don't want to tell our young people that this is fine, that the society supports it, because young people have a real problem with it. Many admissions to the emergency room are for young people thinking they're going crazy because of the strong marijuana they're smoking. At the same time, I totally disagree with Ms. Kao, and I see the job of the Honolulu prosecutor as much bigger and more active in policy. The Honolulu prosecutor works with the prosecutors from the neighbor islands and the attorney general. They have a law enforcement coalition. They've had it for years. They come up with a package of bills if they can all agree on it. If the offices have different proposals that they don't agree on, they bring that themselves. But they bring those to the legislature to improve our laws, to help victims, to give our victims more rights. And I think that's part of the prosecutor's job. I don't see where corruption comes into it. The prosecutors are the ones who know the laws well. The legislators expect us to be there. When I was at the prosecutors before, the penalty for manslaughter was only 10 years. So we fought like heck to get it to be 20 years. So if that was a fallback position for a jury for murder, it went to manslaughter. That became 10 years. We fought the public defenders tooth and nail on that, the defense bar, but we were successful. So I think it's part of the prosecutor's job to go to the legislature, to go to the city council, to talk about laws that could be improved, could be changes. They expect that. They want to ask you questions.
All right, let's move on to another question here. This has to do with the culture. I think you touched on one point, the culture being within the Honolulu Prosecutor's Office right now because of what's happened in recent years. Current Administrator Keith Kaneshiro, prosecutor, I should say, Keith Kaneshiro on paid leave, administrative leave, since March of 2019, after receiving that target letter we mentioned from the FBI during the Catherine Kealoha corruption investigation. So while no charges have been brought against him as of yet, he is taking in a salary of $170,000 a year. Do you feel that he should continue to get paid? And I'm going to start with you, Ms. Kao.
Absolutely not. Keith Kaneshiro should not be drawing in that $170,000 salary, especially because it's my understanding that he has retained counsel and that he is negotiating a plea with the government. And if he knew that that's what he was going to do, then he should have done the right thing and stepped down.
And your thoughts?
Last fall, if he was going to fight these charges tooth and nail, that's the way our system works. That's one thing. But when he announced last fall that he wasn't going to run for election, that would have been the time for him to resign and say, let's let the office move ahead. You know, he could say it however he wanted, but let's get this cloud off of it. Then we could have had a special election in February or March, and that office could have started moving ahead instead of being in the situation they're in.
And a related question to another individual involved in the investigation in some shape or form. 2 weeks ago, Honolulu Prosecutor Achesin Sepolu, returning from leave of absence, that was, I think, that started from back in 2018, identified as a subject in a federal investigation. He's, I believe, back at the juvenile offender unit now. Do you feel he should be back on the job when he, I believe, has not been cleared by the feds yet?
I don't think it's a good idea. 2 reasons. This election is all about restoring trust to the prosecutor's office and who the voters think is the person best qualified to do that. And second, what if he ends up getting charged? Every case he touched, every case he looked at, is going to be subject to a defense attorney motion for it. I don't think it's a good idea. I think they shouldn't have done it, and it's certainly not going to help that office right now for the public to have any more trust in it by making that move.
And yours?
Yeah, I'm very suspicious about the timing of bringing Mr. Sopolu back. It wasn't even 30 days out after the primary election where Dwight Nadamoto failed to go through to the general election. And in addition, nothing has changed. Chassid Sopolu is still under investigation by the federal government. The federal government has not said, oh, it's okay, you're cleared, you haven't done anything wrong. A subject letter means the federal government suspects that you have done something illegal. They don't just hand out subject letters to random people with very little suspicion or evidence. They are serious when they bring that kind of letter against somebody. And the fact that he has access to files, to victims, to confidential information is very disappointing.
So I want to get to a couple of questions that are related, so I think I can kind of handle them together. This is from Jim in Kaimuki, and then up from Nikos on Twitter. Jim saying, what are your opinions on prosecuting corrupt public officials? And then related, Nikos saying, how will you ensure that local police and prosecutors who are engaged in unlawful or unethical conduct are held accountable? How would you approach this arena?
The prosecutor's duty is to objectively apply the criminal law against anybody that violates the law, whether you are an elected official or not, whether you're a politician or non-politician, police officer or non-police officer. It's the prosecutor's office's duty to be objective and to enforce the laws against anyone that violates the law. And so it would not be any different. We would do an investigation. The Honolulu Police Department would do an investigation unless it comes through a different agency. The prosecutor's office will review the file to make sure that there's probable cause to charge the person, and if there is, we will charge them.
And to you, Mr. Alm.
I know how important it is to prosecute public corruption because I've done it. When I was the United States Attorney, we prosecuted Andy Marigatani from the City Council. We prosecuted Speaker Danny Quijano. We prosecuted Milton Holt. We prosecuted Gary Rodriguez. All Democrats in a democratic state because they were the ones who broke the law. No one is above the law. And you have to have the trust of law enforcement that you can investigate things, that they can share secrets with you that you're not going to use against them down the road, or that you have a big mouth and we'll talk about it. And whether it's a police officer, whether it's a prosecutor, they're not above the law. They should be prosecuted. When I was U.S. Attorney, we prosecuted police officers for misconduct and corruption, and they went to federal prison for several years each. That's why I was really happy to get Shopo's endorsement. Ms. Cow and I both lobbied, fought for that with Shopo, and I think they thought I was a proven leader, and so they endorsed me, knowing I had prosecuted police officers for misconduct. But leaders, whether it's the chief, leaders of the union, other police officers, they want the bad cops prosecuted. When we prosecuted the sergeant at Pearl City Station for beating up prisoners, lots of police officers stopped me and said, oh, we're so glad you did that. He makes us all look bad, you know, so thank you for doing that. I did that before, I'll do it again. The law enforcement community trusts me to handle that and do it right. And the investigators at the prosecutor's office should be partners in those kinds of investigations, which is why I don't approve of the prosecutor being appointed by the mayor, because that would be a chilling effect on doing things like that.
And that is one of the questions that we had as well, as far as your opinion on that. That was, I think, Tommy Waters had introduced a resolution to have the mayor have the power to appoint a Honolulu prosecuting attorney, as well as remove and replace that position if needed. How do you feel about that, that being an appointed position?
You know, prior to 1978, it was the mayor who would appoint the prosecutor, and that was before my time. But my understanding is that a number of lawyers got together and proposed an amendment to the city charter because they were concerned that the mayor wasn't appointing someone that was going to investigate the mayor. And so in 1978, we put it on the ballot, and the Honolulu voters voted to make this position an elected position, which is why we now vote for our Honolulu prosecutor. And in 1980, the first person to be elected was Charles Marsland, then Keith Kaneshiro, and then Peter Carlisle was the prosecutor for 14 years with no complaints at all. No allegations of corruption, no allegations of misconduct. However, I believe that there should be a committee, maybe amongst the city council, an appointee by the mayor, an appointee by the city council, or multiple appointees, to make up a committee so that they can do investigation as to who would be qualified to be prosecutor. And then it can be confirmed by the city council. I mean, it's not just black and white. It doesn't have to just be appointed. It doesn't just have to be elected. There can be a combination or a committee that appoints the prosecutor.
So I want to turn it to you and let you respond, but also to add to that a little bit, because Ms. Cow touched on the length of time that former prosecutor, Honolulu prosecutor Peter Carlisle was in office. Constituents voting on a charter amendment in the general election to institute a term limit for a Honolulu prosecuting attorney, 2 consecutive 4-year terms. How do you feel about that?
Okay. Well, I seem to remember at the beginning of this debate of this election last fall, that Ms. Cow did talk about the idea of having the mayor appoint the city prosecutor. I totally disagree with that. And I disagree with some committee of insiders coming up with who they think is popular and ought to pick it. The voters should decide. The mayor shouldn't do it. That would have a chilling effect on investigating the mayor or other city agencies. The prosecutor has to be able to object anyone and investigate anyone without fear or favor. As far as term limits, I think that's a good idea in this situation, just like it is for the mayor. My brother Robbie, I remember him always saying, once somebody, especially in government, has a job for more than 10 years, they start thinking it's their job. That's not the case. You work for the people of the city and county of Honolulu, and I think 8 years is plenty of time for people to get things done with what they're going to do and not be a career politician.
Your response and on term limits.
Yeah, so the term limit is a knee-jerk reaction by the city council to Keith Kaneshiro's misconduct, and it's a bad idea. In Honolulu, anyone can run for mayor because you don't need to be qualified. In Hawaii, anyone can run for governor because you don't need to be qualified. But for the city prosecutor's position, not only do you have to be a lawyer in good standing, you have to have been actively involved in criminal cases 3 out of the past 10 years. So when you look at the pool of people that can run for prosecutor, you're looking at 250 to 300 people in the whole entire city and county of Honolulu that's qualified to run for prosecutor. And if you have to choose someone from that small pool of people every 8 years, you are going to run out of people that are actually qualified. They may be technically qualified under the city charter, but actually qualified is a very different thing. If you look at the people that ran this year, in the next 4 years, you're gonna have people that have never been in the prosecutor's office before, have never been a deputy prosecutor, have never done a murder trial as a deputy prosecutor, have never led a team of people before. You're going to run out of people that are not qualified to run that office.
We do need to move
really
on.
quickly.
Go ahead.
We didn't have any trouble having a lot of people wanting to run this year, whether they were truly qualified or not, whether they had ever led a team of prosecutors, whether they had ever supervised anyone. A lot of people thought they could do the job. We had no shortage of people running for the office. And so I think a 2-term limit does make sense. 8 years is plenty of time to do a good job and not become a career politician and just worry about getting reelected. Name recognition carries too much weight, and it's really hard to dislodge an incumbent.
All right, I want to get to a couple. This is going to be a little bit of a rapid fire round because we want to get to some of these questions here, and they'll bounce around a little bit. This one's from Glenn in Kailua. Do you support, and we'll start with you on this one, Mr. Alm. Do you support the death penalty, is what Glenn would like to know.
I don't, and it's because, I hate to say it, I don't trust district attorneys and prosecutors around the country to do it fairly. You know, it's a very difficult kind of a thing. When I was the United States Attorney, we started down that road with one gentleman because he had spent 95% of his life from age 17 to 45 in prison because he just kept raping women. He kept assaulting people. He'd do it when he was in custody. Eventually, we looked at federal, the federal supermaxes and thought he could probably be safely supervised 23 hours a day. And we offered him life in prison, of course, without parole. He went to federal prison, and after a few months of that, he ended up committing suicide. So it's a very tough thing to do, but I think, it's hurt minorities too much around the country. And I'm afraid a number of elected politicians and some district attorneys and prosecutors, I don't think we can trust them with that. We have life without the possibility of parole. The last case I did at the Honolulu prosecutors as a deputy prosecutor was the murder of a police officer. So Clyde Pinero, who murdered David Ronk, is spending the rest of his life in prison with no possibility of parole. That protects the public. So I think as long as you add that as the option, then we don't need the death penalty.
To you, Ms. Kell.
I believe in democracy, and I believe in the voice of the people. And I believe that if the people of Honolulu or Hawaii vote to impose the death penalty, then I will follow that law and I will execute the law as the voters of Honolulu or Hawaii have voted.
Shifting to another question. This is from Michael in Kahului, asking about, and to you first, Ms. Kell, what would you do about illegal fireworks?
The prosecutor cannot legislate, and the prosecutor cannot unilaterally choose to follow the law when she wants to or not follow the law when she doesn't want to. The laws on the books have to be enforced equally. And so if a case came to the prosecutor's office where, we had video evidence or some type of evidence by a person that observed someone light the firework or explode the firework, then we would have to charge that person just like any other crime.
All right, let me move to this question here. This is from the Hawaii Health and Harm Reduction Center, sent this in from Twitter, asking, and to you first, Mr. Alm, what substantive measures would you do to reduce implicit bias in charging, plea, and trial practices?
Well, as I said before, I did the implicit bias training as a judge, and I think it was valuable because we've always got to look at our belief systems and our thoughts and see if there's anything that unconsciously or not we are doing. And so I would have all the deputy prosecutors do that so they could try to learn, is there anything that they are aware of or not that could affect that? At the same time, part of it is talking about creating a culture of doing justice, not just winning cases. And Berger versus United States is a famous Supreme Court case that I've used for the 4 years I was head of district and family court to talk to all the deputy prosecutors, all the 20-some law clerks I had over the years, about the job of a prosecutor is to do justice. It isn't about winning cases. You strike hard blows, but not foul ones. So at every stage of the system, fairness is the watchword, and it's not just words. We would do it. I do want to point out that Ms. Kao was asked a question about the death penalty, which is tricky, and what do you think, what's your position on it? And she chose not to answer, because it's hard to answer that kind of question. But just, whether saying whatever the people decide doesn't answer the question about what you think about it.
Your response?
Actually, that is my response. I believe in democracy, and I believe that if the people vote for that, then I will follow the law because that's what a prosecutor does. The prosecutor objectively follows the law that has been implemented by the legislature. We cannot, as the prosecutor, unilaterally decide, well, I'm not going to charge this type of crime because I don't like it. Or I'm going to go after these type of people because I don't like them. That is exactly what leads to corruption, and we have to end corruption. The city and county of Honolulu is tired of the kealohas. It's tired of the old boy network. It's tired of what's been done before. We need change, and that is why I'm running.
That's dodging the question. And when you talk about the status quo, I think Ms. Kao is the candidate of the status quo. It's going to be the Nadamoto 2.0. Prosecute as many people and send them to prison for as long as possible. And as the toughest sentencing judge in the courthouse, I sent the violent, dangerous people to prison. Not everybody should get a chance on probation the first time. Some people just have to be removed from society. That's probably 35, 40% of people at sentencing, and the deputies should be trying as hard as they can to get them to prison. But that means other people can and should be placed on probation, and things like drug court, mental health court, hope probation, proven strategies in Hawaii are what we ought to do. You can do both. It isn't either or. It isn't sending everybody to prison or letting them all out. It's prosecuting the right people, sending them to prison, locking them up to protect us, and helping other people succeed on probation so they can get jobs, be taxpayers. That's good for public safety, too.
So, related question here to you, Ms. Kao. Each of you had a different approach to this. You saying that you would charge crimes of all levels as the law permits. Mr. Alm, advocate of probation for lower level offenders. Defend your approach and why you think it would be better.
So my approach is to charge all levels of crime, low, mid, and high level. And this is why. Because the current administration has decided not to charge low-level crimes. For example, if your car is stolen and somebody is driving your car without your authority, the prosecutor's office has decided, well, we're not going to charge that case. The problem with that is the person that gets away with a crime commits another crime, and commits another crime, and continues to commit crimes. And the problem with that is this person becomes emboldened by the criminal justice system. He knows that he can get away with committing crimes, getting arrested, and not being charged and just being released into the community. The problem with that is this person will become violent because the next time, the 21st time or the 22nd time that he steals a car, and the owner says, wait a minute, this is my car. You can't steal my car. This person becomes violent. He uses his fists, a baseball bat, a golf club, a knife, whatever he possibly can. And now we're looking at a homicide. And this is not just something that I'm making up. It happens. We have a girl sitting in OCCC that was arrested 17 times for unauthorized control of a propelled vehicle, but was never charged. She was just let back into the community every single time and is now sitting in jail for murder. So we have to charge all levels of crime. We have to nip it in the bud and show these criminals that we mean business. We are going to charge. But what I do want to stress is I believe in treatment. This is the Hawaii Health and Harm Reduction Center folder. I believe in treatment. We have to put them in jail so that they can decide for themselves. Do I sit in prison and go to prison, or do I get treatment?
I do need to move on, and I want to get your response, as well as also your response on making plea deals in this regard as well, Mr. Alm.
Okay, well, I have heard that all these complaints from HPD that Ms. Kao has too about cases not being charged by the Honolulu Prosecutor's Office. And unauthorized control of a propelled vehicle, they call it that because almost nobody gets caught actually stealing a car. So it's driving a stolen car. And the prosecutors aren't charging a lot of those. I'll certainly look at that if I get in and stop it. But when Ms. Kao refers to that as a low-level crime, to me, that's not a low-level crime. And she had done this at the Kokua Council as well, referring to UCPV, unauthorized control, and burglary. To me, those are not low-level crimes. Your car is your baby. You're really mad. You feel violated. If people come into your house in a burglary, you may lose keepsakes. The amount of money may not be that much, but you never want to lose those. So I'd certainly charge all of those cases because those are serious crimes. At the same time, plea agreements are something that are part of the system. When I was a judge, I'd talk to the attorneys. They'd talk about what the case was. They'd represent what kind of record the person had. And I would give my inclination whether I was going to send them to prison or give them a chance on probation. If the defense said, okay, we can live with that, or they thought that was fair, then the guy would go ahead and plead guilty, and I'd sentence him as is. If they didn't like it, and I said, being a tough judge, no, this guy needs to go to prison, that may have led to some more trials. But as long as it's done up front and it's out there, the defense can just
We do need to move on because we really only actually have about a minute left. But I want to make sure, respond to that also to this question as well. And then we've got about 30 seconds after that for you. The current employees of the city prosecutor's office, they've been through so much over the past few years. If elected, what do you say to them when you start the job?
I was walking down Bishop Street the Friday before the primary election, and I ran into a high-ranking deputy prosecuting attorney, and he said, we talk about this race very often. And I said, oh yeah? What do you guys say? And he says, we talk about how cool would it be to have Megan Cow walking down the hallways with us, fighting in the trenches with us. And I said, that's what you say? And so I would say, I'm so happy to have you folks on this team, and we have to move forward.
And to you, 20 seconds.
I feel so bad for the deputy prosecutors. We know the vast majority had nothing to do with any of the impropriety. I'd certainly look at Kathy Kealoha's cases. Some of them, if she had too much to do with them, might have to be dismissed, and if find any other corruption, root it out. But for the rest of the deputies,
only a few seconds left.
Training them, it's giving them a purpose. It's making the office a place they want to succeed. And they look at me as somebody with proven leadership. I've done this before. I'll do it again. They're really happy if I.
And I have to move on. I'm so sorry. Thank you so much for joining us tonight. We thank our guests, the candidates for Honolulu Prosecutor Megan Cow and Steve Alm. Next week on Insights, another big battle on the ballot, the race for Honolulu mayor. Hear from political newcomer candidates Keith Amemiya and Rick Blangiardi. Please join us then. I'm Laurie Yamada for Insights on PBS Hawaii. Uhui ho.